Hey everyone, in today's show, I'm going to discuss an important topic that is often part of HR investigations, a hostile work environment. In this episode, I'm going to define exactly what a hostile work environment is and what it isn't, so you can do a better job of risk management in evaluating employee relations issues.
Welcome to the HR Investigations Podcast, exploring the issues, challenges, strategies, and solutions. Sponsored by RPCHR and hosted by Natalie Ivy, an HR consultant, licensed PI, and author of the best-selling book, How to Conduct Internal Investigations, a practical guide for human resource professionals. And now, here's Natalie.
Hey everybody, and welcome to today's show. I'm really excited to focus on our topic today, which is on a hostile work environment. So, for those of you who listen to my podcast on a regular basis, you know that I've been in human resources for quite a number of years and conduct investigations and really handle all things kind of employee relations. In one of my previous podcasts, I focused on an episode where I talked about the buzzwords. So that's a lot of what we hear today. Employees throwing out the buzzwords of "you're only writing me up because" insert a protected characteristic such as race, color, sex, religion, disability, pregnancy. And the employees are alleging that in many cases their supervisors are harassing them, and they will allege my supervisor, particularly supervisors, are creating a hostile work environment. Well, what exactly is that? Well, a hostile work environment, it is a form of harassment, and under Title VII of the Civil Rights Act of 1964, as well as other equal employment opportunity laws such as the ADA, the Pregnancy Discrimination Act, and so on, those are creating protected characteristics, and we actually have 11 at the federal level. And so a hostile work environment, by definition, an illegal hostile work environment is as follows. It's discriminatory or sexual conduct that is unwelcome and creates an intimidating, hostile, or offensive work environment that is severe or pervasive enough to interfere with work. Okay, so let me kind of lay that out in layman's terms. What it means is that when you have someone who is making comments such as using racial slurs, making sexual remarks, commenting on someone's bottom that, oh, wow, your butt looks really good in those new uniform pants, or making a snide remark about a woman's pregnancy, right? Those are things that are verbal, but harassment can also be nonverbal as well. The old saying, elevator eyes, really kind of assessing someone, surveying them almost every inch of their skin from head to toe and back up and down again. All right, that definitely is a very sexually suggestive type of harassment, and not a word even needs to be uttered. But then also you can have even physically. And so this could be pinching someone on the bottom, maybe even displaying something on someone's desk. Unfortunately, at the time of this podcast, we've seen a significant uptick in anti-Semitic type of behavior. This is now about 8 or 9 months or so after the invasion of the country of Israel. And so a lot of, the feelings that individuals have regarding that conflict are spilling over into workplaces, quite frankly, around the world, not just in the U.S. But nevertheless, if you had an employee that came forward who, let's say, was of the Jewish faith and said, hey, I have somebody who just left this paper that was written with Sharpie marker, something that was really very offensive to those who were of the Jewish faith, and let's say had a swastika on it, something like that. All right, so you can have physically something that is left, like a document that someone purposefully has used as a form of harassment. You can have physical touching. You can have things that are not even uttered, just visuals. And you can also have things verbally that create an illegal hostile work environment. When it comes to establishing a claim of hostile environment, so typically what would happen is an employee would complain internally, but sometimes they don't always do that. They may actually go directly to the EEOC, that's the Equal Employment Opportunity Commission, and go file what is called a charge of discrimination. So it usually will start there. What happens sometimes is even if the EEOC has engaged in conciliation with an employer, that's kind of the last-ditch effort before litigation in those cases, and they're just perhaps unsuccessful. Well, then the employee does receive a right to sue letter, and they still have 90 days to file a lawsuit in federal court. So sometimes they will then seek legal counsel if, let's say, they were unsuccessful with the matter going through the EEOC charge process. So what are the elements of what's called a prima facie hostile work environment claim? To establish a prima facie claim, an employee has to show the following. Number one, the employee has to show that the conduct they were subjected to was based on a legally protected characteristic. All right, so what are the characteristics? Race, color, sex, religion, national origin under Title VII, then disability under the ADA, pregnancy under the Pregnancy Discrimination Act, genetic under Genetic Information Non-Discrimination Act, and so on. Number two here is objective hostility. So the conduct had to either be so severe or frequent, okay, it doesn't have to be both, but so severe or frequent that a reasonable person in the employee's position would conclude that these working conditions were really abusive. Then number three is subjective hostility. The employee actually found the conduct to be hostile, okay? In other words, like the employee did not welcome the conduct. And then number four is liability. The employer can indeed be held liable for the harassment. All right, so when we're determining whether conduct was objectively hostile, okay, what might we look at as evidence to consider that? So whether conduct creates a hostile environment really depends on the totality of the circumstances. And some things that we may consider include like the frequency and severity of the harassing conduct itself. How physically threatening, how humiliating was it? And did it interfere with the employee's work performance? And if so, how much? Psychological harm, any kind of power disparity, if you will, between the victim and the harasser. All right, so definitely looking at the relationship with like supervisor and direct report. So when we talk about hostile work environment, what I want to get clear about in this podcast is hostile work environment is not just when someone is mean to you. All right. It isn't when maybe a supervisor has been rather abrasive, maybe very abrupt or outright rude, maybe in a staff meeting. That's not illegal. Later, we're going to talk a little bit more about bullying. And in a future episode, I'm going to really parallel the differences between hostile work environment and bullying conduct. So you'll want to stay tuned and listen to that podcast. But what I want to get across, though, is hostile work environment. Those three words are overused so much today by employees, and many just really don't even understand it. Hostile work environment has to implicate a protected characteristic. It is not just kind of a general civility code for the U.S. workplace. It is not. So even though you have an employee who may come and allege hostile work environment, that does not make it so. So you've really got to probe around this when you're doing investigations and really ask, please provide me with some very specific examples of how you feel your boss or a peer or someone else has engaged in this conduct that is in violation of our policies. What exactly do you mean by hostile environment? Describe that for me and get the who, what, where, when, why, how, and get the details. Then find out the frequency. And then when you start asking those really probing questions, then that's where you're really going to start to figure out, are we dealing with hostile work environment and have we had a protected characteristic implicated? Well, sure. If the person that you're interviewing, the complainant, comes back and says, well, my supervisor has made the following, let's say, anti-Semitic remarks, and right in front of three of my peers, said it right in the middle of staff meeting. Okay, well, there we go. Houston, we have a problem. That is a pretty solid allegation. And also when the individual is naming that there are several witnesses who were privy to this, and they will be able to support what the complainant has alleged. All right, so that definitely is one that errs on the side of caution. You'd want to open up a case. On the other hand, when you have an employee who alleges hostile work environment, says, well, hey, my supervisor called me out in front of everybody in the team huddle because I messed up a customer's order. All right, and there wasn't anything in that sentence where the employee said, called me out because of insert protected characteristic and then the customer order issue. No. So without the protected characteristic being implicated in that allegation, we are not in hostile work environment territory. We may very well be in code of conduct territory, unethical conduct. Maybe your code of business ethics and conduct could be implicated. Your respectful workplace conduct might be implicated. You see, your workplace bullying policy might be implicated, but it does not rise to the level of it really being hostile work environment Because if there is no protected characteristic that really weighs in at all, that's not what we're looking at. We're looking at more just general bad conduct, right? You'd have to take a look at the policies for the organization to really figure that piece out. Now, one important thing that I want to talk about here is, especially with management, there is no off the record today. When you have an employee who comes forward and is alleging that they've been subjected, let's say, to a hostile environment, and they want to confide in a manager. Maybe it's a manager that the employee used to work for a little while ago, and they're having a current problem with their immediate boss. So they seek out someone that they can trust in the organization. Often what happens in those conversations, the employee may say, hey, former boss, Amanda, hey, look, I'm really having problems with my current boss, Bob, but Amanda, I don't want you to say anything. I just need to come to you and vent. Okay, hold on. Gonna call time here. If I'm Amanda, I'm going to say to the employee, hey, look, I really need to tell you something here. I'm a member of management, and if you're about to share with me something that could possibly be a violation of our code of conduct or our policies, then I have a duty to report that. So please understand that I can't have anything here that's off the record. Let me tell you why, folks, is when a manager is listening to this type of complaint where there could be illegal conduct going on, let's say it is an illegal hostile work environment, this employee is being subjected to harassment based on some protected characteristic. And even though the employee says to the manager, I don't want you to do anything, it doesn't work that way. Because when that employee comes forward, they are engaging in what is called a protected activity. They are notifying management. That manager, Amanda, is indeed an agent of the whole organization. So let's say the name of the company is Acme. Well, Amanda works for Acme. So when Amanda knows about it, Acme knows about it because she is the representative on the management team, right? So employers also have an obligation under the law, and that means Title VII and other equal employment opportunity laws. We have an obligation to bring a halt to the harassing conduct and then apply an appropriate remedy to hopefully keep that from happening again. Super important that in management training, your managers really understand that there is no more off-the-record type of thing. Okay, the Supreme Court of the United States has really made it clear that employers cannot create a hostile environment that treats employees poorly because of, race, sex, sexual orientation, gender identity, genetic information, pregnancy, and so on and so forth. And so to determine whether a work environment is hostile or abusive, we've got to really look at all the circumstances of the environment. So that means the frequency of the discriminatory conduct, the severity, is it physically threatening or humiliating or just a flippant remark, and whether it unreasonably interferes with an employee's work performance. So those are really the factors that we've got to have a look at. So then we have to look at, does an employer have a defense to these kind of claims? Well, if a supervisor, let's say, creates a hostile environment, let's say manager Bob was creating a hostile environment for employee Justin, and Justin comes forward and tells his old boss Amanda that he really trusts about Bob's bad behavior. Okay, the employer will escape liability if it can prove, number one, that it reasonably tried to prevent and promptly correct the harassing behavior, and then number two, that the employee, let's say Justin in this fictitious example, unreasonably failed to take advantage of any kind of preventive or even corrective opportunities offered by the employer. And so that's usually when HR or employee relations teams get involved and then offer some options for the employee that are going to remedy the situation. Now, if a non-supervisory employee engages in harassment of another, all right, the employer can be liable for this if we knew or we should have known about it and then we failed to promptly correct it. So this is another reason. Sometimes employees, let's call him Justin, if Justin comes forward and tells Amanda, maybe it's not about his current manager, Bob, that's really harassing him. Maybe Justin is really getting sick and tired of his coworker, Sarah, and he's really putting up with a lot from his coworker, Sarah. Okay, so Amanda still can't have this as an off the record as a manager. Amanda's got to really do something about it. And again, that's typically where HR and employee relations are going to get involved and then open up an investigation. An employer, though, is automatically liable and really has no defense in a hostile work environment case if a supervisor really takes what's called a tangible employment action against an employee, like firing them or demoting them. Like the employee complains, and now this employee, maybe it's an employee that doesn't want to go out with a supervisor. All right. So in Justin's example about his current manager, Bob, let's say, Bob is gay and Bob has kind of been putting the moves on Justin, and, Justin is not gay and he has been, let's say, offended by that behavior, or even if he is, doesn't matter. He just isn't, he's not into his boss. He doesn't want to go out with him. And, he finds the fact that the boss is coming on to him really pretty darn defensive. So then because, the boss has sort of had his affections not returned, if said boss is like, oh, well, he doesn't want to go out with me, well, I'm just going to figure out a way to get rid of him, and then either fires or demotes the employee. I can tell you that can lead to some expensive claims. So this is why it's critically important that we do really, really good management training and that they understand their obligations. It also means we've got to do very good investigations. So once management becomes aware of a complaint of harassment, immediately an investigation needs to be launched by also a neutral, unbiased party, typically HR or employee relations. Now, if it's unlikely that the investigation could be conducted by someone neutral and unbiased, this is when you've got to look maybe at a different division or business unit. Try to reach out to an employee relations partner or HR business partner that is in a different division of the business that could be maybe more neutral. And if you really don't have that available, then that might be time that you go outside the organization. And certainly if you're looking for external investigative services, you know where to find us, rpchr.com. And this is the type of work that we do for organizations pretty routinely. Okay, so that brings me to the end of today's episode, and I really hope that this has been a good investment in your time today and learning a little bit more about those buzzwords, the hostile work environment. So that's it for today's show. Until next time, I will be delving into the differences now between hostile work environment and bullying in our next episode. All right, everybody. Till next time, see ya.
Thanks for joining us today on the HR Investigations Podcast. Be sure to subscribe, like, and share the show with any colleagues who will benefit from our strategies and solutions. For free bonus resources, simply visit hr-investigations.com. And remember, if you'd like some help with improving your investigative skills, or if your organization is in need of an external investigator to help with the case, please get in touch with us. Thanks for listening, and we'll see you in the next episode.